Let's discuss the merits of the former statesman's recusal arguments with Stellenbosch University Public Law Postdoctoral Fellow, Dr. Tanveer Jeewa. Dr. Jeewa, thank you so much for your time and for joining us this morning. Perhaps maybe could you just simplify the legal basis for President Zuma and Mbeki's applications for Justice Khampepe's recusal, and what do you think are the main legal arguments presented by both former statesmen to justify their requests for this recusal?
Good morning, Tanveer. Thank you so much for having me. So in essence, former President Zuma and former President Mbeki, even though they're both trying to get Justice Khampepe recused from the Judicial Commission of Inquiry, they are actually alleging things that overlap but are not necessarily similar. Let's start with former President Zuma. He seems to have more or less three issues. Mostly that there was the prior involvement in TRC structures, which is that Justice Service Khampepe previously served on the Amnesty Committee of the TRC and also later held a senior prosecutorial office, right, which was that she was the deputy NDPP, thus forming part of the National Prosecution Authority. This is something that former President Mbeki is also relying on. So I will start there. And also, importantly, former President Zuma says that former Justice Khampepe, because of the judgment that she has penned, which we call the contempt judgment, which is the judgment that later end up having former President Zuma imprisoned, has shown bias towards him, has shown, in his own words, deep-seated hatred and animosity in the judgment. And there is finally the strongest allegation, in my opinion, which is that Justice Khampepe has given advice to Advocate Semenya over their own recusal matter, right? I believe that the last one is actually the strongest allegation, but we can talk about that later. That would just be a brief summary of the allegations.
And I mean, as we're unpacking these allegations, Zuma claims that Khampepe showed bias when advising the evidence leader on a recusal application. How significant is such a claim in the context of judicial impartiality?
So this is, to me, the strongest legal argument that they would have on recusal, because it's important to know that there is usually a presumption that the judge is not biased and the judge will apply a fair mind to the matter. Now, because of that, the burden relies strictly on President Zuma to prove that this bias exists, right? So if they have to prove, right, this is important, they have to bring forward evidence that advice has been given to Advocate Semenya, but also what a lot of people haven't been talking about is what kind of advice has been given to Advocate Semenya, right? Is it substantive advice? What I mean by that is, was she straightforward about the arguments that Advocate Semenya must be looking at or putting forward, or was it procedural advice? Because you are allowed to also ask as a chairperson to be informed about maybe some legal matters. So it's very important that the evidence is put forward so that we can know actually if there has been advice given, one, and two, if that advice has been given, then what kind of advice exactly are we looking at? But as I've said before, in terms of all of the allegations that has been made, I believe that this is one of the strongest argument, because that is the one where the main question where you ask, would a reasonable, objective and informed person on the true facts think that Justice Khampepe will not bring an impartial mind to the inquiry? I think that's the one where we would take a step back and think.
Do you think that these are purely legal concerns, or do you think there could be some political motivations behind the president's concerns?
Sure. That's actually a very interesting question, because we haven't really spoken about why exactly are former President Zuma and Mbeki interested in this at all, right? But it's important because the Judicial Commission of Inquiry, in looking at why exactly the investigation or prosecution of TRC cases haven't taken place, means that exactly after the TRC has ended, we're going to look at these presidential terms, right? Which means that there's going to be failures on the part of institutions that were governed by former President Zuma and Mbeki. So it's interesting to know that they do have a political interest in this, which is obviously why President Zuma even brings up the fact that there is an actual bias against him because of the content judgments, right? So I wouldn't think these are strictly legal allegations. I think there's a political agenda in there, but that's obviously my opinion. But based on these facts, that's what I would say.
And maybe let's just talk about the importance of judicial neutrality in commissions of such a nature. How might these be perceived in terms of the conflicts of interests, and how would this impact the credibility of the TRC?
Yeah, that's an interesting one, because Justice Khampepe, obviously, we spoke about her being involved on the TRC Amnesty Committee, but also in the National Prosecution Authority. I think what a lot of us haven't really been discussing is that these institutions did different things, had different mandates, and she occupied a role in both. What do I mean by that? So obviously on the Amnesty Committee, she had to be part of the process that actually looks at which people or whom deserves actual amnesty, right? But then again, in the NPA, what you need to do is actually prosecute the people. Here we are looking at a commission of inquiry that investigates into the failure of the NPA as well. So the allegation that Justice Khampepe would be biased because she was part of the TRC and hence want to prosecute the people and see failures is also kind of contradicted by the fact that she was at the National Prosecution Authority, where they should have prosecuted the people, right? So this is very important, back to your question, in terms of the integrity of the chairperson. This is obviously a very important judicial commission of inquiry, especially for South African democracy. And we do need someone who is impartial and fair, but also importantly, we need someone with institutional history, right? The discussion that she has been involved doesn't automatically disqualify her. If anything, I would think it gives her more experience. Having been involved in these two almost contradicting institutions means that she's seen both sides of the coin, right? The need for accountability, but also the need for forgiveness and granting amnesty. So, yeah.
So, I mean, speaking on that institutional knowledge, we know that a lot of the times it's the families at the helm of this TRC that are really looking for restitution. The Galata group suggests that the application to recuse Justice Khampepe is an attempt to undermine the Commission's work. How common are such tactics, especially in a politically sensitive investigation such as this?
Yeah, unfortunately, we've seen over the past few years, as I'm sure you've seen as well, all of us, with Judicial Commission of Inquiry, there are so many different applications, either for recusal or trying to tackle the integrity of the Judicial Commission. And a lot of the time, what these are is that, one, Stalingrad tactics, for example, here to delay the Commission of Inquiry possibly. But another thing that's interesting is looking at the integrity of the Commission of Inquiry, right? It's the importance of saying, well, if we've claimed that this person, the chairperson, is biased, and they still proceed to chair, despite this recusal application, we are now playing to the media, we're playing to the court, so that if the Commission of Inquiry ends up finding against us, then we can come forward and actually say, well, we said she was biased all along. And this has happened before. We've even seen it beyond Judicial Commission of Inquiries with the Constitutional Court, when former President Zuma had said a lot of things that were, plenty of animosity against the Constitutional Court. And then when the Constitutional Court actually put out a judgment, to then come out and say, well, we do not believe in the integrity of the Constitutional Court. We've kind of reject its jurisdiction on these matters. So, yeah.
And maybe in just the broader implications as we close off, what do you think that this case sort of reveals about the challenges of maintaining judicial independence as well as impartiality in politically charged situations such as this one?
I think we've seen it in South Africa over the past decade a lot. I mean, that's why people even term it as lawfare, where we've seen like a lot of political involvement comes and plays itself in the courts, right? We've seen it a lot where judges have to actually sit down and distill legal matters away from all the political noise. Because even though you and I are speaking, we're talking about the political agenda, that shouldn't be relevant when you are a judge and you're presiding over a matter like this. In this case, we are not talking about whether former President Mbeki or Zuma distrust Justice Khampepe, whether they are uncomfortable, and so on. What we're actually talking about is there a reasonable apprehension of bias, that she will not be impartial. That it is a strictly legal application. But unfortunately, as we've just discussed over the past few years, we've seen a lot of political interferences which delay a lot of these processes, right? Like, I'm interested to find out what exactly this Judicial Commission of Inquiry is going to find, and why are two former presidents so amped on actually getting the chairperson out on a recusal note like that.
And you keep talking about the delays and the Stalingrad tactics. What then would be the implication should she recuse herself? Where does this leave the commission?
That would leave the commission with actually finding another chairperson, right? Like, the president would have to appoint a new chairperson. That would probably take time. But beyond the time of appointing a new chairperson, the new chairperson will need time to actually acquaint themselves with all the papers and all the matters. And like I've said before, Justice Khampepe's institutional memory is going to be of import here, which is why she's familiar with this. But importantly, if we remember, these recusal allegations are actually quite broad, in the sense that this probably would disqualify anyone who has been a TRC commissioner and anyone who's had a long-standing role at the National Prosecution Authority. Or if former President Zuma was to win on the whole animosity in the judgment, anyone who's actually found a judgment against former President Zuma, which would leave us with a lot of people out of the selection ring. So it would take quite a lot of time.
Sure. Surely a lot of precedences might be set by this particular case. Doc, thank you so much for your time and for your insights. That's Stellenbosch University Department of Public Law Postdoctoral Fellow, Dr. Tanveer Jeewa.